Good afternoon, everyone. Welcome to our second webinar that MRA is holding. I want to double check before starting if we want to wait a little bit for more participants or should we kick off? Okay, good to go. Thanks, Stephanie. So again, a very warm welcome to all our participants and our panelists for joining us today for a very important discussion. I'm really delighted to be your host for this webinar and great to see many dedicated individuals in our virtual audience. First, just a brief introduction of the theme of the webinar. Today, we're talking about the online court decision observatories, which is a tool for promoting women's rights in Morocco and Tunisia. This event is organized by MRA organization, Mobilizing for Rights Associates. So MRA is an international nonprofit organization which is based in Morocco and working across Maghreb and especially in Tunisia. MRA collaborates with many stakeholders. We work with local NGOs, youth-led NGOs. We work with lawyers, with law universities, with students, and all these efforts are oriented and aim to boosting women's rights and providing them with better protection for their rights and giving them better positioning in society. I've been volunteering with MRA organization since many years, since I was a student in law school, and even now, while pursuing my professional career, I'm still happy to continue volunteering with them and being part of their huge work and important work that's helping many women protect their rights and their efforts into boosting women's rights across the region. As well, today we have with us a group of women activists and believers in women's rights that have been working on this project since many years and working on making it grow and expand. We have with us Stephanie, who is a founding partner of MRA organization, Saida, who is as well a founding partner of MRA organization. We have with us from Tunisia, Munira, who is the project coordinator in Tunis. And we have with us as well a Moroccan journalist, Layla, who is a journalist at Telkel magazine. So before we dive into the discussion, I want just to present general rules of this webinar. The webinar will last approximately around 90 minutes. It will be split into two parts. First part will be question and answers format, where the participants are encouraged to engage with the panelists, and you please feel free to share your thoughts or questions or anything you want to share through the chat discussion. And then the second part of this webinar, the panelists will respond to your shared questions. As well, additionally, we will be sharing key resources and links on the screen, and as well, they will be available on the chat for your convenience. This way you can explore further information related to today's topic. We have a lot to cover today and we're really eager to get started. So maybe first thing we want to start with is an introductory overview question. Stephanie, could you tell us more about what's exactly the Marsadnissa online observatories in both Tunis and Morocco?
Thank you so much, Noor, for kicking off the webinar. Thank you, as you mentioned, for all of your years of participating and mobilizing and volunteering and working with us in the project in Tunisia. So thank you so much for that. Sure. Very basically, the two observatories, because there are two of them, and here on the screen you can see the two home pages. There's one for Morocco and one for Tunisia, and they're basically online databases of court decisions from a diversity of jurisdictions across both of the countries, across Morocco and Tunisia. And when we say a diversity of jurisdictions, we're talking about a diversity thematically. So decisions from administrative courts, from family courts, from commercial courts, from regular first instance courts, etc. We're talking about a diversity of decisions from a geographic level. As you and Munira know very well, the way we work across both Morocco and Tunisia is to work in decentralized local communities across the country. So the court cases in both of the observatories aren't just the court cases from the large capital cities, but from a diversity of the smaller cities and towns across both of the countries. And then a diversity of court decisions in terms of level of the court. So we're not just restricting ourselves to decisions, say, from the Court of Cassation. But the observatory has cases from the Court of Cassation, from different appellate courts, from different first instance courts, as well as from even some of the resident judges. So that's what I mean by diverse. The decisions in the observatories are also diverse in terms of issues related to women's and legal and human rights. And the different laws and codes in the different countries that might impact them. So while given the context in our two countries, a lot of the decisions are certainly about family law or personal status code, as well as penal code, there are also a diversity of other issues related to women's rights in the workplace under the labor code, etc. So there are a diversity of cases under all of these different types of laws in the two observatories, whether related to divorce or related to violence or sexual or reproductive rights or what have you. And we'll see on another screen, we'll see that the two observatories are trilingual. In other words, there's an Arabic platform, a French platform, and an English language platform. So users can navigate the observatory in the language of their choice. Obviously, when it comes to downloading the court decisions, the decisions themselves are in Arabic, the original language, but at least we designed the platform to be accessible to people in all three languages. Perhaps I'll just add one final point, which is how the observatory databases are built up. It's not we don't have an elite team of lawyers and specialists sitting in an office being paid just to do this and build up the observatory, but it's really built up through a participatory process of crowdsourcing, if you will, court decisions. Because from our partner NGOs, we work with local NGOs across both of the countries who have working groups with other NGO members, lawyers, activists, students and professors at law schools, other types of legal practitioners who share court decisions and help build up the website. So if you will, it's a very horizontal and organic process of building up the website. And as you can see here on this screen, one of the functions is share a court decision. And so one of the functions allows people to share a court decision. So you can create an account and become a contributor, and you select and you code and you analyze and you upload cases. So the hundreds of cases that you see on both of the observatories really are the result of widespread grassroots level participatory contributions from a diversity of people across both of the countries. And I'll stop there for now. Thank you, Noor.
So much, Stephanie, for all the information. And as has been described by you, the observatories seem to be very sophisticated and well-built tool in a very well thought way. So it's obvious that there was time and effort invested into building these tools and into thinking how to build them as well. So maybe I'm moving now to Munira and ask her what was the reasons behind creating them and investing that much time into these tools.
Thank you, Noor, and all the followers and panelists This initiative aimed to create an observatory database that would allow legal practitioners to keep up to date on decisions issued by Tunisian courts, as well as a practical tool for lawyers to develop effective arguments for written and oral pleading, and for judges to write decisions in women's rights cases. It was also designed to highlight on how legislative texts and their interpretation by courts are based on gender stereotypes, and thus prevent women from fully enjoying their human rights. So this initiative stemmed from a different set of challenges, which is represented in, firstly, we wanted to encourage access to information for legal practitioners or professionals, all stakeholders interested in gender justice, on issues related to the human and legal rights of women. This was dependent on overcoming a number of obstacles, the most important of which are, for example, there is the absence of an integrated information system for the justice system in Tunisia and Morocco, in a way that enable access to information. There is no system for collecting and publishing court decisions, as is the case with some electronic platforms such as Westlaw or LexisNexis. These are platforms that provide search service throughout the database available on the platform. And there are a few limited resources, which are mostly on business or commerce topics, as well as academic publication or periodicals related to selected decisions issued at the higher court level. In contrast, there are no publicly accessible sources that collect in thorough, systematic, and methodical manner cases issued by courts of first instance and other lower courts. So, especially in courts of first instance, where the majority of cases related to women's rights are decided. We also found in our work that local activists and researchers often highlight the difficulties in reaching judicial decisions. They describe obstacles such as difficult or impossible access to courts and their archive, lack of consolidated, complete, organized, or up-to-date court records, and also the limited of human resource and financial resource. So, secondly, this initiative aimed to promote uniform application of the law by all courts across the country throughout the ability to access and share various court decisions. Where there is a lack of uniformity and the application of law and policies, in the absence of standardized policies and procedures, and local public actors develop their own interpretation and practices. Sorry. As a result, we find that similar cases can be treated quite completely differently depending on each region or the individual justice system actor managing the case. If we talk, for example, the launch of the work of the Tunisia Observatory, Marsadnissa, Tunis, Marsadnissa, Tunisia, coinciding with the new legislation, some protection decision issued by various courts in the Republic of Tunisia, and we try to examine.
Mira, we lost you. I'm not sure if you still can hear us.
In terms of text, you listen to me, Noor?
Yeah, now we can hear you. You're back.
Yes, I said, and we tried to examine the jurisprudence of these courts in terms of text or procedures to monitor the direction of different courts with regards to protection decisions and related measures taken in accordance with the meaning of the Basic Law 58 of 2017. So we will note the hesitation of the Tunisian courts in dealing with the text of the new laws, especially the law 58 related to eliminating violence against women. For example, among the judges, there are those who consider that the protection decision is temporary and urgent measure that requires a decision on it in the shortest possible time. Other judges go to issue protection decision after more than 6 months and after successive session which represent danger to the victim. Here it should be noted that the platform provides us with a sample of these issues. The ruling show that the public opinion case does not represent an exception, but rather there are many cases that enable monitoring and demanding the activation of the law. And on the specificity of gender-based violence. Therefore, we seek in our electronic observatories to monitor in the level of implementation of the protective measures established by the new law, and accordingly that they be avoided in the future. At the same time, we stand on the good judicial jurisprudence contained in some protection decision. In light of this, we are not limited to dealing theoretically with the law legal text only, but also testing realistic issues and examining the practical problems of protection procedures and the clarification between the text and the reality. These texts have no meaning if they are not fair to women who are victims of violence, and unless they were protected before, the judiciary is entrusted with ensuring rights and freedom in according with the Constitution. It's also worth noting that the sample in the Tunisia Observatory does not represent an example of all hypotheses related to the application of protective measures, but it does provide a practical example that enable us to draw conclusions that can be adopted. If I can speak about the international human rights, Noor.
Yes, Munira, especially if it's related like to the reason behind creating the webinars. If it's part of another question, we can just mention that later, but it's up to you to decide. Yes.
How many time I can, how many time it rests for me?
No, it's not about the time. If you think this is related mainly to the reason behind creating the observatories, please go ahead. If you think it's related to another question, we can leave this to
it's
later.
related to this question.
Yes, please
yes,
go ahead
it's
then.
related to this question. Question. It's very important to speak about the international human rights conventions, also in both countries, such as the CEDAW or many international human rights. They are directly, they are important to be practice in jurisprudence. So the background and the role for creating these two observatories was that they were the result of a group of scientific research conducted by MRA organization, MRA for MRA Women organization, on a group of issues such as research conducted by the organization on the application of international human rights standards before the courts, whether in Tunisia or in Morocco. During the meeting that took place with the lawyers, judges, and those interested in using these universal standards related to gender justice, we received many answers. There are those who believe that these standards remain at the theoretical level, and there are those who believe that it's not possible to use these standards before the courts. There are also those who say that it's about lawyers who don't demand it, or judges who don't want to work with it. This means that we found that there is no consensus on the use of these standards. Throughout the observatory, we were able to monitor many cases in which not only international standards were excluded, but also local law. Here we can see an example of one of the courts that excluded to use of law 58 and excluded to use the chapter 222 of the Penal Code. The court's ruling was not, this court's ruling was not appropriate for the crime of treating, which requires criminal punishment according to the chapter 222 of the Penal Code, even if this threat was verbal only. Were verbal only, despite the fact that the new Tunisian constitution stipulates the criminalization of all forms of violence against women in the Article 46. The court also did not rely on the definition of moral violence contained in Law 58 of 2017, which criminalizes any verbal assault such as insult, such as deprivation, such as humiliation. And that's why this initiative situate in context of monitoring the application of recent law in both countries, 2017 in Tunisia and 2018 in Morocco, and current advocacy for family code reforms in Morocco. That's all.
Thank you so much, Munira, for the extensive answer and all the details. Before moving forward, I would just ask you if you could change the subtitles to English, because now we're seeing them in Arabic. Meanwhile, I would want to ask Stephanie in case she has anything else to add to that, especially from perspective from someone who founded the organization and who started the work on the implementation of the observatories.
Thank you. Thank you, Munira. I don't think I have very much to add to the extensive description that Munira gave of all of the reasons that led us to create the observatories. As Munira described, it was a combination of obstacles, right? Whether it's the current personal status and family codes in both countries, or the recent 2017-2018 laws on violence against women in both countries, have all of the laws and many others. They've got the legal gaps. They have lots of different provisions that are discriminatory against women, are frequently not implemented, and as Munira noticed, they're frequently not in harmony either with the new national constitutional standards or the international human rights standards. So those were some of the challenges and obstacles that led us to create the opportunity. But then, as Munira explained, there were also opportunities that we saw that needed to be seized, namely that in the legal context in both countries, both Morocco and Tunisia, which might be a little bit more different than some of perhaps the common law Anglophone countries where some of our participants are tuning in from. In the systems here, international human rights conventions are such as the CEDAW, are justiciable, meaning that any party to a case can actually raise them directly in front of a court, and they're also directly applicable. In other words, judges and theories can decide cases on the basis of international conventions. So this was an opportunity we wanted to seize, and Munira gave a couple of examples in Tunisia of how local courts set aside national law to apply international conventions directly, which was also the case. I can give a quick example of the case in Morocco, where, as you know, in many of the countries in the region where we work in, the personal status or family code laws give child custody, physical custody to the mother, but legal guardianship is in the hands of the father, even after divorce, which impacts things like mobility and decisions over financial management, etc. And one of the decisions that we found and put on the observatory was where a judge decided to exclude Family Code Articles 178 and 238 related to child custody and guardianship with the father. And on the basis of Article 10, Paragraph 2 of the Child's Rights Conventions, on the right of children to leave their country, actually allowed the child to get a passport and travel out of the country with his mother, and without the father's authorization, and give the mother the power to manage the child's assets, etc. So another good example of opportunities that led to us wanting to create the the observatory.
So much, Stephanie, and thank you again, Munira. So now, after covering what is the essence of the observatories and why they were created, maybe it's worth going and walking through how to use these tools. I already know they are user-friendly tools because I've used them previously, but for the benefit of people who are listening to us and who are not that much familiar with the observatories, maybe Munira, if you can walk us through from practical perspective, how can people use Marsadnissa online observatories?
Noor, if I can add to the question one, and then I will answer to the question two, if it is possible for the time.
Yeah, if you can do like that very briefly, and then we move to the next question, that would be great. Thank you.
Yes. Thank you. While we had included among the recommendation in the recent Tunisia Monitor report on removing legal and institutional obstacles that perpetuate violence and discrimination against women, especially to achieve equality in inheritance, and to abolish discriminatory laws, including the provision of the personal status law related to the dowry in the chapter 12 and 13, the roles and the responsibility of spouses in the chapter 23, the homosexuality and the individual freedom in the article 213 and 125 and 226 and 226 of the Penal Code. We were surprised by the new Tunisian constitution that was voted on Tunisia in 2022. Because today there are growing fears among large segments of Tunisian women and feminist movement and organization that the gain achieved by Tunisian women will be reversed. And we have found ourselves facing a constitution that legitimizes the religious states. All of them consider that what raises concerns in how these laws are interpreted and how the constitutional court work and a constitution from which the term of civil state have been removed. So this fear is due to the underestimation of women's rights and discrimination against them in the Islamic heritage with its various schools, which is discrimination that appear especially in the family institution, given that the headship of the family with its broad powers over the children and even in deciding the fate of the family goes back according to this relationship to the breadwinner is the head of the family in the personal status code. So I pass now to the question number two. How can people use the Marsadnissa Online Observatory? The observatory provides all research and those interested in researching how laws are applied and throughout the search engine, as well as the fluctuation between the legal reading of texts and cases of their application in judicial decisions and rulings. The platform also has the feeder of search function and also a sharing courts decision function. It is not just an electronic library, but rather a detailed multi-criteria search engine for selecting and comparing court decision based on a set of options, whether procedural or substantive, depending on the question asked and the factors to be tracked or studied. For example, question users may want to ask are, for example, how is a specific article of a law being applied? And this is what makes it possible to draw conclusions from the good jurisprudence in the court and the extent of their effectiveness in confronting violence against women. For example, another research hypothesis, for example, are there conflicts across jurisprudence on certain, and here it is possible to identify the shortcomings that have been observed in the applied procedures established in the law at the court level. For example, also we can ask it, how are international human rights conventions being applied by local courts in order to determine the extent to which the courts rely on the implementation of international human rights standards and new constitutional measures related to women's rights, for example, the good, the good implementation of the new legal gains, most notably the Basic Law 58 of 2017 in its civil and in its penal aspects. Also, the researcher can ask about, does it make difference if the judge is woman or man? And in this question is based on gender, about the extent of the relationship between the announced ruling or decision and the judge's gender. So it is also important to note that the observatories include a wide range of decisions across jurisprudence and courts level. It is not just about the exciting and often exceptional, but also about everyday news that impacts women at the grassroots level on a daily basis. If I can give an example, Noor, or I can report it after Stephanie is speaking.
We can have like a couple of minutes, additional couple of minutes for that, for the example, and then we move to the next question.
I don't understand. I don't hear you, Noor.
And can you hear me now? I said let's have 2 minutes for the example, and then we move for the next question.
It's okay for 2 minutes. As an example of this, there are many decisions in the Tunisian observatory, Marsadnissa, Tunis, which prove that despite the revision made to the chapter 23 of the Civil Code in the Civil Code, judicial jurisprudence has remained stable, stating that choosing the material residence by custom and law is the husband's right as the head of the family, and that the wife refusal to cohabit with to cohabit. If she refused to cohabit, she is considered So I said that some courts of first instance and appeal considered in some of their rulings that the wife's insistence on not cohabiting with her husband without giving valid reason, despite the many warnings that were sent to her to resume cohabitation after he had prepared a place to her, is considered disobedience and a breach of her duties toward her husband in violation of the provision of the law that obliges her to do so. So it's a duty as required by custom and tradition. So despite the revision that was introduced to this chapter, it did not have a significant impact on the general orientation jurisprudence, which remained preserving the stereotypical image that the duty of cohabitation falls primarily on the wife, and that she must live with her husband in the place that he prepared. Thank you, Noor.
Yeah, for all these details, really insightful. And what you've provided explains exactly how the observatories work, and confirms again that they are not just user-friendly, but they provide a range of services that do not just allow people to access an online library, but provides more tools. So these observatories are, of course, a tool that could be used by anyone. However, they might be specifically useful for some people compared to others, especially for lawyers and human rights activists. Could you explain to us how they are specifically more useful and could be used as a strategic tool for these people, which means lawyers and human rights activists? And let's start with Stephanie on this question.
Thank you, Noor. I guess I'll start building on what Munira mentioned earlier, which is that what Munira mentioned earlier about there not being sort of a system of court reporters, what LexisNexis, Westlaw, Recueil de Jurisprudence, etc., which means that judges and lawyers don't necessarily know how decisions are being decided across different jurisdictions. So the first way that the observatory could be a strategic tool for lawyers and activists is through strategic litigation. In other words, by having an observatory of different court cases with perhaps good best practices and creative ways in which lawyers are pleading cases or deciding cases across the country, practicing lawyers can access information and also share creative legal arguments used by their colleagues, and access those used by their colleagues in other parts of the country, access information on how judges in jurisdictions in other parts of the country are deciding cases in their own litigation, if they come across a similar case. And here, we, especially in places where the law might be unclear or is open to interpretation. So one example that we can give from the Moroccan context is the recent Law 10313 criminalizes psychological violence, but it doesn't, really provide a definition or explain what it is. And one of the cases in the online observatory was a violence against women case where a woman the judge found that she had suffered trauma from threats from a group of men against her, and the judge actually sentenced the aggressors to prison, not on the basis of threat to commit, a violent act, but on the basis of psychological violence and the trauma she suffered from those threats. So it was an interpretation of the law that if it's widespread and shared across the country, other lawyers can be encouraged to refer to this, to use this, etc., and in their own arguments, as well as judges, to be able to see how other places in the country are deciding different courses. So that's the strategic litigation, individual court decision angle. The second angle really is the advocacy angle, because what the observatory is allowing us to do is to monitor and document how the laws are being applied by courts, allow us to plot trends in the current justice system response, and identify problems in the language of the law or its interpretation. And what that's going to allow us to do is help reinforce advocacy-based, that's going to help us reinforce evidence-based advocacy for future law reforms. And as we know in both of our contexts, sometimes advocacy is based more on ideology than proof or science. So we want to really push evidence-based advocacy of why or how a law is or is not working, to advocate for future law reforms. And given that in Morocco, for example, we're in the process of preparing reforms to both the family code and the penal code, it's very important that those reforms be made on the basis of evidence. And the other aspect strategically of doing using the observatory for advocacy is that we're able to gather good practices of how the laws are being applied across the country that feed into our theory of change. So we know in both of our countries, change has really been quite sometimes top-down, legislative change. And we often hear arguments in resistance to change that, the people are not ready, or the people are, conservative, or we need awareness raising or whatever. But having an observatories where we see examples of good practices, of how lawyers are arguing, of how judges are applying, of how prosecutors are prosecuting, if we base our advocacy on those good practices, what we're basically asking the legislator to do is to confirm and consolidate what already exists in practice. So we're actually not asking, the legislator to do this radical, revolutionary top-down reform, because the things that we want are already in place. And we're just asking them to confirm and institutionalize it. So in the Moroccan example, there were a couple of good cases that came up on this. There was a recent case in the courts where a group of men who had raped a minor girl were sentenced to very minimal prison sentences. And that got a lot of coverage in the press, and which we won't go into detail now because Layla might want to address that. But the initial discourse was that, this is a problem with the individual judges, and they need awareness raising, or they need sanctioning, or whatever. But having in the observatory allowed us to say, no, this is a trend. This is a pattern of behavior. This is a systemic problem that's coming from the penal code itself. It's not a problem with the individual judges. And so that's very important for for advocacy and understanding that it's a systemic problem. Another case that was very interesting is, again, in our countries and other countries that don't recognize children born out of wedlock. In one interesting case in the Moroccan courts, a judge actually did make a distinction between paternity and legal filiation of a child born out of a legal marriage. basically by referring to different international standards, including the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, the Child's Rights Convention, etc., to decide that preventing a child born out of marriage of paternity was against equality principles, and made that distinction and recognized that the child had a right to financials, to support and to a name, etc., and making that distinction to expand rights. So that's one thing that we could build on to do advocacy in the reforms to the family code. To better protect the rights of children born outside of marriage. And then maybe a third example of how practitioners are trying to improve the law themselves is that in one case, there was a minor, a child who was married. She was a child because she was under age 18, but she was married and she was arrested and could have been charged under the adultery provisions of Article 491 of the Penal Code. Whereas, clearly she's a minor, she's underage, she can't consent. And the prosecutor in this case actually did ask to not charge her as a minor with adultery, and made a very creative argument about as a minor, she's unable to consent. And that's something that's completely absent in the Moroccan Penal Code as it is right now. The outdated definition of rape in the Moroccan Penal Code now is against her will. And one of the big advocacy points for the reform of the Penal Code is that rape be redefined as against, the consent of the person. So unfortunately, the judge in this case, according to the decision, refused. But having this case on shows a different change of practice, by prosecutors, by other legal professionals, that it's important to build on. So basically, we see that in terms of being a strategic, practical tool, the observatory can be, a tool for individual case advocacy when a lawyer sees an interesting interpretation or argument that can be used in a particular case he or she is litigating and get a better outcome in that case. The observatory can be, a tool for systems advocacy, for broader change to the laws, etc. The observatory, it can also be used as a tool, for media coverage when it can highlight injustices in a certain case. But we'll leave that for Layla to speak to later on in her role as a media professional.
Really useful, and the examples are really interesting, and it's really important to have these good practices, as you mentioned, stored in one place and accessible in an easy way, so that we can build on that in future cases. And while we build that on and have more positive examples, this will even help in the advocacy efforts as well. I'm sure Munira will have other examples for the Tunisian context, but being aware of the time, maybe Munira, if we can limit that to one example from the Tunisian context on how the observatories could be useful strategic tool for lawyers and activists.
Yes, Noor. We can add a Tunisian example about women's right today. To cast today are less than men's rights, than men's rights according to the personal status code. Outside of this article, there are many laws that still discriminate against women, including the nationality law and the condition for granting citizenship to spouses and children. The concerns relate to how this law will be interpreted, in addition to the disruption that will occur at the level of improving and developing the legal text. So I think that this observatory can be an advocacy tool, an important advocacy tool.
Thank you so much, Munira, and I want to extend my thanks again to Stephanie for all these details and examples. Before moving forward with Layla this time, I want just to remind all the participants in our webinar that they are very welcome to ask their questions or share their thoughts with us through the question and answers box. And then at a later stage, once the part for questions and answer with panelists is complete, we can move to answering their questions. As have been previously mentioned, the observatories are useful tool for a range of people, but specifically useful for some professionals. And from these professionals, it's specifically useful for journalists. Can Layla tell us from her perspective, how can the observatories be useful tool for media professionals, and what kind of impact does reporting on court decisions have? Maybe you can even mention some examples of some court decisions that you've worked on during in relation with your professional career.
Okay, hi everyone. Do you hear me? Okay.
Yes, perfectly.
So as Stephanie said before, I work a lot on cases about violence against women, and this observatory will be a huge tool for us journalists, because we always struggle to have the court decisions. I sometimes call Stephanie and say to her, "Do you have this this case? Do you know what the judge said?" And so we don't have the accurate information, and we don't have the data also. So this observatory really changed things for us, and but in a good way, obviously. And it's always also a really good tool for French-speaking journalists, because here in Morocco you can find the court decisions, sorry, but it's in Arabic. And me, for example, I don't read or speak Arabic, so sometimes I don't know how to find these informations. So as it's in French and also English, it will help a lot of French-speaking journalists here in Morocco. And it's also a really good tool to compare data, as said previously, because we have big cases like in April, there was a big case here in Morocco. 3 men raped a young girl. She was 11 at the time, in Tiflet. And it's because of activists that we knew that the 3 rapists got 18 and 24 months. They got sentenced to only 18 and 24 months, which is nothing. So some activists contacted us, and we wrote about it a lot, and it changed. I think they got something like 20 years, 10 and 20 years. 1 month later, but we didn't have any tool to inform ourselves about this decision. So we always have the information either from activists or from the lawyers. So this observatory will be a really good tool, and will allow us to write about the systemic problems, as Stephanie said before. Also, the fact that we have the judge gender will allow us to write about the fact that judges need formation. We try to write about it, but we don't have the data. We can say men judges are less, I don't know how to say it, will not condemn men, or we don't have any data. So this is a huge step for us to advocate as a journalist for the judges to have a formation on violence against women and children. And these tools allow us also to write about these problems, but to change the public opinions. Because in this case, Tiflet, there was people all around the country were talking about it on Twitter, and it's because we wrote about it. Not only Telkel, other medias wrote about it. So when you have a whole country against this decision, you have to change it. And so we will be able to speak about more cases like that, and the systemic problems, and raise public opinions about all those systemic problems that we have here in Morocco. Because it's not the only case that is problematic. I think 2 weeks ago, I contacted Stephanie about a case in Ouarzazate, where a young man was raped by a guy much older, and this. So the rapist was convicted and condemned to 8 years, but the victim was also convicted for homosexuality, which is just crazy. So we were looking for the case, and we couldn't find it, and we didn't have the number of the lawyers, or so we didn't have the details of this case, which is a scandal, actually. So we can't write about it unless we have more details. So when with this observatory, we'll be able to have more insights on those cases, more data, and we'll be able to raise, I hope, public opinion and change things. Voila. I don't know if you have more questions, or if you need more details.
That's already super useful, but we will be very happy to hear more from you if you have like other examples, or you have any maybe suggestions that you think could be useful to integrate or to add to the observatories, and that would have a positive impact on journalists' work.
No, I'm not a lawyer, so I don't know how to improve this observatory. I think it's already great that we have that, because and I stress that we really struggle to find details about those cases, because if the lawyer doesn't call you, you don't have anything. So you just no, you can't write about it, because our work is to give information, and we don't have this info. So I don't know how to improve it. It's I think it's already great, but those cases, they are we spoke about stiflets a lot. We made a cover here in Telkel about it. But you have these cases, I think, every day here in Morocco. There is really a problem with rape, with the definition of rape, as Stephanie said, with pedophilia, and I can give you one example, because you have those every day here, and we don't hear about it. And through this observatory, we will be able to speak about, to write about these cases, because when it's in small towns, when it's in Casablanca or in Rabat or Fès or Tanger, we have ways to find about those cases. But when it's in small towns, we won't hear about it. So through this observatory, we'll be able to write about those victims, and I think that's great.
Can you hear me now? Is it better? Okay, thanks again, Leila. And I really want to emphasize on journalists' role in the advocacy for women's rights. It's true that maybe lawyers are positioned in a different place because they have more access to information, in like live information related to some cases. But advocacy role of journalists is crucial and really important in the whole process. Other than that, I think we're approaching the end of our webinar, the first part of our webinar. We've already spoke about many aspects ranging from the motivation and the need to the observatories, how they can be used, and their huge impact on women's rights. This is obviously a project that we want to see grow and expand. So maybe Stephanie can tell us more about next phases and upcoming events with the two observatories.
Sure, thank you, Noor. I mean, yeah, clearly we want to keep enriching and expanding the two observatories across Morocco and Tunisia to keep them updated with the most recent cases, because if it's not fresh and updated and current, you know, the usefulness is not at 100%. And you know, why not, you know, expand to other countries, right, on a regional level, because across, you know, North Africa, or the countries with a common heritage in terms of court structure, you know, from the French, it's a very, you know, the platform, the structure could fit, given, you know, the countries across the region basing a lot of laws on religious sources. There could also be, we think, you know, an interest in cross sharing how courts outside of just the previous Francophone countries, but, you know, Egypt, across Middle East, North Africa, how they're deciding issues that judges might be basing on religious laws. So we'd love to do the expansion regionally. I think now that we've got it set up, we want to think a little bit more strategically about the analysis piece of the observatory content, and make sure that we're supporting our partners and the people who, so the people who contribute to the observatory, but also the people who use it and who read the cases, to analyze the court decisions from a human rights perspective, and supporting that either through a series of trainings or practical guides. And by a human rights, you know, framework, a human rights analysis, we're looking specifically at a couple of things. You know, how can we do a more detailed and in-depth analysis of these of the court decisions based on the General Recommendation number 33 from the Committee on the Elimination of All Forms of Discrimination Against Women, the General Recommendation on Access to Justice, because that general recommendation gives a good framework for analyzing court decisions in terms of the 6 obligations it sets out of states to ensure access to justice for women, whether it's justiciability, availability of mechanisms, accessibility of mechanisms, the good quality of judicial systems and their accountability, and the fact that women, get appropriate remedies. So that's a already in existence framework that would be very helpful for analyzing the court cases, as well as there's sometimes the 5 Ps and sometimes the 6 Ps of state obligations in gender-based violence cases. Are states meeting their obligations to prevent, to protect, to prosecute, to punish, and to provide remedies, right, as a way and a framework for analyzing decisions related to women's rights case, to violence against women cases. And then working with all of our partners on issues of judicial stereotyping based on sex and gender. So it's not just the issue of the actual written laws or their gaps or their lack of clarity, but some of the cases in the observatory allow us to really see the language that the judges are using in their decisions and to refer to different things. And so working with our partners to support them to identify better, types of stereotypes, whether it's sex stereotypes or gender stereotypes or, role attribution, characteristic stereotypes or role stereotypes or sex stereotypes or compounded stereotypes, providing our partners with that type of framework. We're looking and we're thinking creatively about how to get the information out a little bit more on a regular basis. We already have, as you know, Facebook pages for both of the observatories. So highlighting, cases of the month or bad cases of the month or good cases of the month, as well as producing, looking to produce more formal regular reports or periodic issue papers on specific themes and how on the justice sector response. So a host of different outputs and things like that. And then in terms of our, strategy, continually, as you know, looking at how we can expand our partnerships with law schools, not just in the countries we work in, but perhaps in abroad, bar associations, other legal professionals, et cetera. So those are some of the things that we've sort of been brainstorming in our mind, and we look forward to feedback from everybody.
So much, Stephanie. Before moving to questions, I just want to double check with Munira in case she wants to add anything regarding next steps. Maybe if there is something specific to the Tunisia office, if there is anything that is specific to be implemented in Tunis and that she wants to add to that.
I think that as long as there are discriminated laws, our work will continue, and this initiative aims to encourage the application by courts of international human rights standards and the new constitutional provision related to women's rights and recently enacted laws such as the law of Morocco, the new laws of Morocco and Tunisia. So I think that our work will be continue in Morocco and in Tunisia, and MRA for Mobilising for Rights Associate will continue to in partnership with grassroots civil society organization and lawyers and law students and other legal practitioners and justice system professionals and local working groups will collect and upload and analyze judicial decisions and judgment issued at different levels in courts from diverse jurisdiction across the country of Tunisia and Morocco. Ongoing assessment of women's access to justice throughout monitoring local court decisions, particularly critical in light of the new constitution and the new laws in Morocco and Tunisia, and recently enacted laws related to women's rights.
Thank you so much, Munira. I think it's time to move to the second part of the webinar and dive into some of the questions. So first thing, I've seen one of the participants write something about the decisions shared on the observatories being translated, and that we only have now Arabic version. So that's a question from my side now, building on this comment. Do we think maybe of using AI tools, especially that it's like there is a rise in using AI tools, and adjusting it with the legal terminology and using that for the purpose of translating the the court decisions that we have on our observatories, which will make it easier to be used for non-Arabic speaking people. Maybe Stephanie can answer that if she is happy to.
Yeah, that question kind of puts me in a tight spot because one, we, as legal practitioners and people of the law, right, language is everything, and you have to be precise. So I guess in the language and just changing one word can make a big difference. So I guess my question would be, the question was about the court decisions are in Arabic, and unfortunately, we to date have not had the resources, to be translating all of the decisions ourselves into English and French. And so even if people navigate on the English and French platform, then you do get the original decision, and then folks kind of have to figure out how they're going to access that depending on their own purposes and resources. If you're needing it for, say an official court case, you're going to have to get official legal translation of that, for example. And even if you're a student, I would think you would want something, as accurate as possible. Again, because we're talking about the law, and we're talking about specific languages. And, and as people who work with professional interpreters, quite frequently, we've got a ton of respect for and appreciation for the necessity of their work. On the other hand, the AI possibility is not something, we're not tech people, so we're not quite sure how that would work and what the opportunities and challenges would be. So it's a very interesting suggestion to kind of take into consideration that we would definitely want to explore further. And again, it would probably depend on the uses to which people would want to use the summaries and and our own resources.
Thank you so much, Stephanie. Another question that's a bit catchy. Maybe this one is for Munira. It asks, to what extent did the observatory reach its objectives? So we obviously had set a lot of objectives, and we're making great progress, but it would be great to hear from someone who's been working on the project many years, from their perspective, how much they are satisfied of the implementation and in terms of reaching the preset objectives. Munira, over to you. Were you able to hear me asking?
I don't hear the question, Noor.
The question is, to what extent did the
If you can
observatory...
repeat the question.
Yes, sure. Can you hear me now?
Yes.
Okay, so the question is, to what extent did the observatory reach its objectives? Were you able to hear me? Or maybe there's a delay in the sound.
Yes, I hear you now.
Okay, maybe I can write down the question. Stephanie, is there a problem in hearing me as well for you, or you can hear me well? Okay, so Munira, the question is, to what extent did the observatory reach its objectives? And I will copy paste it for you in written so that you can see it in case you cannot hear me.
I can't hear you good, Noor.
I have sent you in written the question, but if there's still a problem, maybe we go ahead with Stephanie.
I'm happy to answer that question while Munira is looking at the written and getting that sorted out. I think yeah, the way that we look at sort of impact or results is multiple. And assessing kind of what happened and assessing if the objectives were met or not. It's not just were the objectives met, it's also, were there any unintended results or unintended impact, right? We're always keeping our eyes open for that. So we tend to look sort of at four large domains when we're looking at evaluating our work. One is obviously the content of laws or judicial decisions impacting women. And so in that domain, in terms of both the better outcomes in individual cases, in terms of the better outcomes in individual cases, yes, getting examples of lawyers who have creatively litigated based on examples they found in the court case or creative interpretations. We've seen that happening on the systemic level that I mentioned earlier in terms of using it for systems advocacy and better laws. Get back to us maybe next year when we see what the new family code and what the new penal code in Morocco look like, and hopefully some of the advocacy points that we bring up in our advocacy to lawmakers will be based on the evidence we got from the court decisions will show up in the laws, and so we'll let you know. The project had a whole bunch of structural objectives as well, just in terms of capacity building of a host of different actors, lawyers, NGO activists, law students, etc., in terms of building people's capacity to analyze by certain, frameworks, develop skills to collect and code court decisions and upload them, access to information, that sort of capacity building. And that, I think in both countries, that was achieved. And just in the fact that the observatories are public, the third culture objective in terms of, better transparency of court decisions was also achieved. I think the unintended result that we hadn't thought about, that we saw most of all, was in the fourth area of change, which is in relationships. The different local NGO partners that we worked with and on the ground really did create working groups to collect and upload decisions onto the website that amongst a diversity of people. So we're talking grassroots level NGOs recruiting lawyers who before didn't necessarily get involved with NGOs, law students, law professors, uniting civil society and universities, with journalists as well, in the local working groups, etc. So that sort of relationships change. And then relationships change between perhaps lawyers and activists with the lawmakers and decision makers, because having evidence and having valid, credible arguments based on facts from the cases with which to do your advocacy, leads to a little bit more credibility and openness by the decision makers to meeting with civil society for activism. So that, that's the relationships change that I think was not intended, but that we did notice on the ground.
Thank you so much, Stephanie, for all these for sharing all these details about next steps and envisaged growth of the project. I think it's already almost time. We have 1 minute left to respect the time. So before we conclude, I want just to remind everyone, all the participants, that they can find all the valuable resources, updates, and further information on the observatories' work on their respective websites and Facebook pages. Which have been displayed, and they are now displayed on the screen, and that we will share as well in the chat. For any additional inquiries or questions, we're very happy to be in touch with you. Email. You will have our email address as well shared in the chat box. I'd like to extend my thanks and appreciation to all the participants who joined us today and are engaged to support women's rights. I want to thank the panelists who have been sharing with us very valuable information and details related to the observatories work, and to Layla for sharing her experience from a journalist perspective. We look forward to your continued involvement in our upcoming webinars. In this series of 3 webinars, we already held one in Arabic yesterday, and we're going to hold a 3rd webinar tomorrow in French. It will be held at 2 p.m. Morocco and Tunisia time, if I'm not wrong. The video recording of the 3 webinars will be shared later on our social media pages. So we would be very pleased if you could share them in your wider network for more reachability for other people, and to share all these information amongst your networks. Again, thank you again for your commitment to promoting women's rights in Morocco and Tunisia, and looking forward to seeing you in upcoming webinars.